Hello and welcome to this Regulatory Transparency Project virtual event. My name is Jack Derwin and I'm Assistant Director of RTP at the Federalist Society. As always, please note that all expressions of opinion are those of the guest speakers joining us today. To learn more about our speakers and their work, you can visit regproject.org to view their full bios. After opening remarks and discussion between our panelists, we'll go to audience Q&A if time allows. So please enter any questions into the Q&A box at the bottom of your screen. Today, we're pleased to host a conversation titled Section 230, Common Law and Free Speech. To discuss this topic, we have a great panel featuring Brent Skorup, Kristian Stout, and Thierer. Adam, who will be our moderator today, is a senior research fellow at the Mercatus Center at George Mason University. He specializes in innovation, entrepreneurialism, internet, and free speech issues, with a particular focus on the public policy concerns surrounding emerging tech. With that, Adam, I'll pass it over to you.
Well, thanks so much, Jack. I appreciate it. And on today's webinar, we're going to be discussing the ongoing debate over digital content moderation policies and Section 230, which, as almost everyone knows now, is the provision of the 1996 Telecom Act that basically says that digital media platforms and other online services are not legally responsible for the content posted by their end users. While Section 230 and the case law surrounding it was once a fairly mundane matter, it has now become a highly charged political issue with many policymakers and pundits on both the left and the right lining up to take a swing at the law in some fashion. Indeed, proposals to reform Section 230 have been multiplying rapidly in Congress over the last couple of sessions, as well as at the state level, where many bills have been advanced to regulate social media platforms in some fashion, with a few already being enjoined in the courts. While I have actually lost count of all of the activity going on in Congress on this front, I know there have been at least about a dozen proposals over the last session or two. And what is remarkable about these proposals is how a great many of them actually contradict each other in some fashion, with some parties favoring Section 230 reform such that we encourage more content moderation of some sort, while other parties want reform to encourage less moderation of some sort. The only thing seemingly unifying these reform proposals is a desire for some sort of expanded regulatory and/or legal oversight of digital media platforms and potentially a whole heck of a lot of expanded liability to go along with it. So recently, the International Center for Law and Economics released a major study setting forth another reform proposal related to Section 230. That study is entitled, Who Moderates the Moderators? A Law and Economics Approach to Holding Online Platforms Accountable Without Destroying the Internet. And it's my pleasure today to welcome one of the three co-authors of this study, Kristian Stout, to today's webinar. Kristian serves as Director of Innovation Policy for ICLE. Welcome, Kristian. Also joining us for today's discussion is my colleague, Brent Skorup. Brent is also a senior research fellow here at the Mercatus Center with me. Brent has written extensively on these issues and most notably published an article in the Oklahoma Law Review in 2020 on Section 230 and publisher liability in American law, which provided a really wonderful historical look at these issues over the last couple of decades. Welcome, Brent.
Thanks for having me.
Let me begin by first asking Kristian to briefly outline some of the key takeaways from the big new ICLE paper, and then to tell our listeners how your proposal matches up with other key reform proposals currently being considered at either the federal or the state level. And then I'll ask Brent for a little bit of follow-up, and I too will have some follow-up questions. Kristian, take it away.
Great. Thanks, Adam. Happy to speak with everyone. Thanks to FedSoc for putting this on. I think it's an important topic. As Adam notes, there have been a large number of attempts to reform Section 230 over the last several years, more than I think I can count as well. And what inspired us to start working on this paper was to look at where those efforts were trying to do something good and where they often go off the rails. As Adam notes, I think there's a lot of contradiction behind what those reform efforts have been trying to do, in part because I don't think that there's been a very good theory about how you want to approach Section 230 type of intermediary liability online. So our paper starts from the perspective of asking if we have learned something over the last 26 years since CDA 230 became law, if we've learned where there are suboptimal amounts of harmful, illegal, or tortious content that can be potentially discouraged without over deterring free expression, we want to find those places. So that's what our paper is trying to do. One thing I want to stress about our paper, which everyone should go and read, because really it's quite a great paper, is it's only a working paper. We're trying to start a conversation about how you actually reform Section 230 in a way that optimizes the legal regime so that you get less harmful content, you still preserve free expression. So when we have our proposal, which I'll go through in a quick second, we're not saying we 100% have arrived at the actual answer that everyone needs to adopt. What we're trying to do is walk through the law and economics analysis of how you think about the trade-offs involved in content moderation. And then we take that in our paper, and then we have a section at the end where we say, well, this is how we think that this works out. But we require the input of a lot of people who've been thinking hard about this. And there's a lot of people, I think, who have very good reasons for why they think Section 230 works great and they don't want it to reform it. They're afraid to lose those benefits. Our position is that there's probably more room in the Section 230 regime such that we can actually deter some of that illegal content. So broadly, we think that Section 230 is a good thing, has been a great thing for helping develop internet content. I think, and I think my co-authors would agree with this, that given what everybody knew in 1996, looking at how the case law was starting to develop, it was not completely unreasonable to try to create Section 230 the way it worked. So we are not looking in our proposals at any kind of a total repeal of Section 230. What we're looking at is trying to find an incremental way to look at the margins where bad activity occurs and look for ways that courts can actually start to move the line of what counts as a liability protection for Section 230 as new harms start to emerge that can inform and update the way Section 230 works. And we want this to be progressive. We'd like this to be a common law type of approach. And we think that this will ultimately yield a better fit for incentives. So generally, what we're saying is that we think Section 230 intermediaries liability protections for illegal or tortious content for the behavior of third parties, it should be conditioned on taking reasonable steps to curb that conduct for platforms, subject to procedural constraints that will make sure that a tide of unmeritorious litigation doesn't actually swamp all the benefits of Section 230. So what we do in our paper is we walk through what, like I said, what those law and economics cost-benefit analysis components would look like. Generally speaking, that's going to be looking at how you determine what the costs of litigation are, both meritorious and unmeritorious. Obviously, the cost of meritorious litigation is not something that should count against a reform because you have reasonable content cost or reasonable litigation costs there. You want to look at what the benefits of more speech are over common law baseline, and you want to look at what the benefits of controlling more harmful behavior are in that current regime. One of the lacuna, I think, in this area, and we haven't solved this, and it's something that I don't know that we as a community can solve until we actually start to look at experimenting with how to change Section 230, is how to understand fully what the actual litigation, unmeritorious litigation costs would be if you allowed more litigation at the margins. So to a certain extent, it's hard to answer that question. And that's why we think that what you need is this progressive, very incremental set of changes that take place over time. So this way there's something like an escape valve where if you start to see this start to swamp the benefits of the expression, you can actually change this as it's going forward. So generally speaking, at a high level, what this means is we think that platforms should have a reasonable duty of care that it owes for the administration of its services for non-communications related torts. For communications related torts, we think that largely you should keep the regime as it is, with perhaps adding in a layer that's something a little bit closer to distributor liability, but not in the way it traditionally worked in common law. We think that, for instance, something more like a court order, if there's a no fault, sort of a no fault injunction approach. If a court declares that something is defamatory, a platform would have an obligation to take it down at that point. And the way this would work in the litigation process is that there would be a certified set of best practices that a platform has agreed that binds them. they would be able to present this in a pleading stage so that if someone came in and brought a case alleging that they breached their duty of care, they could present these certified answers or certified compliant practices. And that essentially would be they would get a safe harbor at that point. The plaintiff at that point in litigation would then have a heightened pleading standard, something like fraud, where they would have to show that no, in fact, the platform did not comply with its best practices that it's certified. And they would have to deduce more than a mere complaint. It would have to be some sort of evidence they could bring forward to show that in order to get through the Section 230 safe harbor. That whole process we envision as emerging, or compliance with best practices, we envision emerging from a multi-stakeholder process where companies and people from relevant interest groups can get together and look at the kinds of harms that everyone's concerned with, figure out what the best practices are for platforms to deal with these, relevant to the size and scale of the kind of platform that's at stake. And that if the practices emerge from that, the whole thing would be convened by a competent federal agency. We don't see the federal agency as having any kind of input into the actual standards. Their job would be more to facilitate the process. And critically, what their job would also be is to collect the results of these best practices from the litigation process in the district and state courts that see these cases, and be able to prepare reports to give back to this multi-stakeholder community so that you can start to see this updating process for the best practices. And then finally, we think this whole process should sunset. At some point, industry and the multi-stakeholder groups would be continuing to develop these best practices. The federal agency would no longer be responsible for facilitating this process, and then courts would have a new reasonableness standard to administrate at that point.
Before I turn to Brent, let me ask two quick follow-ups, Kristian, for you to elaborate on. First, who exactly establishes that multi-stakeholder process, and is there a model? I've done a lot of work on multi-stakeholderism in other contexts, and NTIA is one model. FTC has got another. Maybe there's some other body you're thinking about. That's question one. Question two is, maybe you can say just a bit more about your duty of care requirement and how that compares with others that have been set forth. I think Brookings had a paper, or someone did, Daniel Citron,
right.
Ben Wittes. So maybe you can answer those two questions before I turn to Brent.
Yeah, I think, all right. So the first question is, where would the multi-stakeholder process originate? That's a very difficult question. I don't know that I have an easy answer for that. We looked at different agencies that have convened these, and different groups like ICANN and NTIA, FTC has done some of this process. I don't know that we have a firm answer on that right now. That's the kind of thing that I think, if people like our proposal and actually want to work with us on that, that would be something that I would look for a lot of feedback on. Generally speaking, I think the ones that we were leaning at, we're looking at something almost like the way NIST is involved in standards development and in that process. That was one of the more appealing ones, but I don't have a ton to say on which agency should convene that. The point of the federal agency is to make sure that there is some sort of authoritative convening of this process, right? So locating that would be something once this proposal goes further down the road. On the reasonableness standard, Citron and Wittes have good work on this. I think that the way they wrote this, I don't want to misrepresent their work, so anybody can correct me on this, please. The sense that I got from the way they wrote this is that they would be more interested in this becoming more of a full common law, general reasonable duty of care, from the get-go. There's going to be no limitation on that. There is some overlap, I think, with their idea and ours, in that I think that they would agree probably that what you're really looking at is a duty of care in the design and administration of your services. It's not per se that you want to hold platforms liable for the third-party speech of users, but if you're designing services in a way that users are able to more easily conduct harassment or revenge porn or a lot of the different harms that we see happening online, that the platforms have a role to play in facilitating removing that material. I think that we're more hesitant to just throw this completely into the courts up front, because I am very sensitive to the concern that the litigation costs would be really, really quite large immediately, at least while that system sorts itself out. Over the course of 20 years or something, maybe that would actually resolve down to something more reasonable. I think immediately it would not be a great way to go about that. On the Brookings paper, if I remember their proposal correctly, they actually advocated almost a very similar, but almost an upside down version of what we're saying. I believe they wanted a federal agency to actually convene something like what the UK models are thinking about, actually create an agency that develops these standards and then promulgates them to industry. I think that there's legal vulnerabilities in that approach. And I also don't like a centralized management of the way that would work.
Gotcha. Okay, so Brent, let me turn to you and ask you to comment both on what Kristian had to say about the study itself, and then also bring in some of your own work or compare some of what you're hearing here to what's going on currently in Congress in the States.
Yeah, if I may, I'll talk a little bit about my own paper, and there is some overlap with Kristian's. But so Jennifer Huddleston and I, my former colleague, wrote this paper a couple of years ago. It was published in the Oklahoma Law Review in 2020, right when all the Section 230 controversies hit. And it was a very fortuitous timing for us. But so the paper, we document the long history of publisher liability in American law, and frankly, the erosion of publisher liability. You had, with publications, with newspapers and books and so forth, in the 19th century, you had a regime of strict liability for typically, I mean, if we're talking about publications, and even what Section 230 was originally about, it was about defamation online or defamation in print. And courts over a century have essentially gotten rid of publisher liability and approached what Kristian mentioned, this idea of conduit liability or common carrier liability, which is essentially no liability at all, with some narrow exceptions. And Section 230 is of course a very broad liability protection that resembles, we say, conduit liability, and actually resembles where courts were going with publisher liability. Starting this in the 70s, courts, I mentioned in the 19th century, you had strict liability for publication and defamation. In 1933, you had the Supreme Court case in Florida, the Lane case, where they created what's called the wire service defense, which is essentially if you're taking information from a wire service and republishing it, you're not liable for that republication. And this evolved over time. You had broadcasters get covered by this wire service defense. You had cable companies. You had Newsweek. I mean, it started to expand into print and even into what we would call curated or edited material. There were some cases in the 90s. Broadcasters. There was perhaps the clearest case was a federal case in the early 90s. Some apple growers brought a defamation case against, I believe, 60 Minutes and the local CBS station for this alleged defamation of apple growers using pesticides. And in the court, in that case, and it was followed by other district courts in these TV cases, said, no, these are conduits. We can't expect TV stations to go through all their programming, their tens of thousands of hours of programming, and identify, make on-the-spot decisions about what's defamatory and what's libelous, or be subject to multi-million-dollar lawsuits. And your ears should perk up. I mean, this is exactly the justification for Section 230, which is we can't have online companies staffing up, getting warehouses, law firms full of lawyers making on-the-spot decisions about what is illegal or defamatory. And so we trace this history, and frankly, I mean, this is always wonderful when this happens. This was not the paper we intended to write. It was only by looking at the case law that we, uncovered that there was this expanding wire service and conduit liability that resembles in a lot of ways Section 230. And our conclusion is, Section 230 resembles what was happening in the common law, resembles the protections that, say, TV broadcasters have today, and even some print media. And it also came at a fortuitous time when online companies were starting to become commercial and develop. And actually, this is you see in history, liability protection for these infant industries, and Section 230 is liability protection for an infant industry, and it's an open question. The internet is not an infant industry anymore. Is it time to reevaluate? But I think at the time it was a remarkable law. Has done a lot of good for free speech and technology in the U.S. We conclude our paper by saying, as Kristian said, there are these harms online which are becoming more and more common. The internet is not, again, it's not an infant industry anymore. Facebook, Google, Amazon, so forth, they're not prodigy. They're not a bulletin board operator in the 1990s. So what can be done? Where can public policy do some good in diminishing some of the harms? And Jennifer and I, we point to 3 conditions that you would probably want to have a carve out from Section 230 from liability protection. This would be conditions, types of speech where there is essentially unanimity that's low value speech, low value type of speech, that this speech can be easily identified by software or by non-experts. The reality is these companies have hired a lot of non-experts and a lot of people all across the world to determine what's permissible and what's not. And so any type of speech that requires difficult decision, defamation is a good example. You can't decide what is defamation with a non-expert or with software. And so, unanimity that's low value. It can be identified by non-experts. And the third condition is that devoted efforts to remove this speech would not have a lot of collateral censorship. And frankly, there's not a lot of speech or content that would satisfy those. One we point out and it comes up frequently is revenge porn. This is outlawed, or there's some liability in almost every state in the U.S. at this point. It's low value speech. It can be identified by non-experts, and dedicated removal of revenge porn is not going to have a lot of collateral censorship of high value speech. Another might be like illegal rentals online. You can identify if something, let's say Airbnb is illegal in jurisdiction, it might be a dumb law, but it is a type of content that would satisfy. It's low value speech. You don't have a lot of collateral censorship, and it's easily identified by non-experts. But and we hope lawmakers will keep those principles in mind. Our paper. I think both sides probably see something they like and don't like about it. I think if you're a critic of Section 230, you might say, well, we don't need Section 230 at all. Courts would come to a common law solution in time, and that's true. But that in time, that could be decades. I mean, it could be centuries. I mean, common law is a slow process. But that's the paper in a nutshell. I guess for Kristian, I really enjoyed the paper and really glad to see others working, alongside. I would say, somewhere in the middle where, there are some who believe Section 230 is this, kind of word of God, this perfect law, given to man. That's a slight exaggeration, but and there are others who believe it, causes all the harms online, and that, again, that's a slight exaggeration. But there's a lot of us in the middle who see, it's not perfect, but it does do a lot of good. Yeah, I'm curious, what your perception of other countries. Other countries don't have Section 230, of course. Would you say they have fewer online harms? Do they have less speech? We have a natural experiment, if you will. We have countries that don't have Section 230. What would your paper? Do you have a perception of that? What would your paper say about other countries without Section 230?
Yeah, that's a great question, and I think it's worth probably doing some sort of comparative study to look at that. I mean, off the top of my head, the difficulty is going to be the legal traditions and the social environments and sort of the government policies. Nobody has a First Amendment. We're one of the only ones that have a First Amendment. So off the bat, the baseline is going to be very different about what can and can't be censored. So like for instance, you can't sell Nazi memorabilia in Germany and France. The environment that's operating in is a completely different kind of environment than what we're facing. So I don't actually have an answer off the top of my head. I think it's a good thing to think about and probably worth doing like a follow-up comparative examination to see if there are some lessons we can learn there. Most likely, you would need to limit your examination to common law countries, because I agree that the common law likely would have arrived at something similar to Section 230, and it might have taken decades or a century. But what we really want to learn from is a common law approach. I want to stress that we don't want to advert to a civil law country that has strong tendencies towards centralizing its public policy. Even though arguably we do that a lot in the United States anyway, we want to look at how you can have evolutionary norms for developing these things.
So let me follow up with both of you, and I'm actually going to take off my moderator's cap here a bit and kind of push back a little bit, because Brent mentioned there's some folks out there who think that 230 is the greatest law. Well, I might be one of them. I wrote a piece called "The Greatest Internet Law," talking about how Section 230 was one of the key pillars of the sort of permissionless innovation environment that differentiated the United States from Europe and other countries and allowed our companies and our innovators to really flourish in this country. But I want to ask a question far more broadly. Kristian, your piece is about sort of the law and economics of liability in Section 230. And that is a topic that's always been of terrific interest to me. I come from the perspective of someone who believes, as the great Aaron Wodolski once argued, that economics as applied to liability law needs a major revision. Because our tort system in the United States is fundamentally broken. And when I search the Federalist Society website for tort reform, I find a couple of hundred of results talking about the need for reform on various grounds. Our tort system, of course, number one, lacks any sort of loser pay rule to deter frivolous lawsuits. And number two, it's since the New Deal era been very much focused on redistributing incomes by searching out deep-pocketed folks who will pay, even when they are not the parties primarily who are the cause of the problem. And so my own defense of Section 230 has admittedly been a little bit of a reductionist or consequentialist approach, saying, look, part of the goal here is to counter a badly broken tort system and deter frivolous activity to allow innovation and speech to flourish. And it's not uncommon for Congress to sometimes tweak liability standards. I mean, we had the National Childhood Vaccine Injury Act of 1986 to deal with the fact that tort lawyers had really discouraged the development of childhood vaccines in this country. That tweak by Congress turned around that situation by granting some liability exemptions to childhood vaccine makers with some new sort of new evidentiary standards for risk analysis introduced into the courts. Number two, we had the Protection of Lawful Commerce in Arms Act to deal with firearm lawsuits in 2000, and I believe 5. And so there are examples like this, right? And so turning back to your paper, you say, let me see on page 37, a few expensive lawsuits in exchange for optimal deterrence could easily be a net social benefit. And my question to you would, why should we believe that there will only be a few lawsuits in our overly litigious system that encourages so many frivolous claims to be filed, Because once you have a duty to care sort of standard on the books, I just think that people just start filing suits left and right with a more amorphous duty to care standard. And then number two, what counts as optimal deterrence? You guys never define it in the paper. Turn it back to you.
Great questions. Yeah. So I'm completely sympathetic to everything you said about the brokenness of our tort system, and I am very sensitive to the way of defending Section 230 on this consequentialist grounds. It definitely has a sympathetic note for me. That said, in principle, if we think that there are harms occurring online, that could be deterred, that there are real people whose lives are suffering, and there's some way to tweak the way the liability shield currently works, in principle, I think that we have an obligation to consider how we can alter the liability regime, try to preserve as much of Section 230 as we can, but figure out ways to actually help people who are being harmed under the current regime. On the idea that the specific question on how we figure out what socially optimal balance between harm, and it's a great question. I don't know that, and this kind of goes to what I was saying in my initial remarks. I don't know that we can actually create a formula right now where, we do like a hand formula and we figure out, even though the hand formula is obviously not exact, but there's no formula that you're going to be able to come up with right now to figure out what is socially optimal. That's almost an emergent fact that has to occur based on allowing courts to examine some of these things. So putting all of this together, this is why we got to the point where we're saying what you need are marginal, very incremental changes to the regime that take place slowly over a long period of time, that are guided by courts, and that have more procedural protections around these kinds of suits to make sure that it doesn't become just a honeypot for plaintiffs' attorneys to go in and just try every theory they possibly could. What we want to, there probably will be more filings under the way we're envisioning this, but if we're correct in how we're thinking about the procedural reforms, and if other people's inputs helps us refine that idea, you'll still get something like a lot of automatic dismissals at the pleading stages for people who cannot overcome that initial heightened pleading standard over the certified standards.
See, Brent, did you want to follow up at all on that? Unmute yourself. There you go.
I mean, just a thought, as I was reading the Kristian's paper and his co-authors, I enjoy the paper. There's a lot of great work in there. For me, I can't separate, and courts haven't separated. If you look at the history of conduit and republication history, the practical issues surrounding republication and moderation, censorship, and the free speech implications. And so applying a law and economics framework, I love law and economics. My career has been in law and economics, but I don't see these issues of media policy and are so tied up with free speech that I'm not convinced we can apply an economics framework to issues of free speech. If we could separate, the practical issues of content moderation from the speech, I just don't. I wish we could. I just don't see a way around it. And I just want to add this whole issue, and this might be funny coming from someone who's written a lot about Section 230, but I mean this debate in Congress. I mean, this is an aside from the paper. This debate in Congress. I mean, this has become a political hot button issue for the left, for the right, particularly for conservatives in Congress. And I regard it as a tragedy, really, that we have hearing after hearing, dragging tech companies in to defend themselves for whatever the controversy of the day was. When I really don't see much wiggle room when it comes to Section 230. I mean, I think there can be some tweaks around the edges, but this has just consumed our political class for so long. And It's really resembles the media fights of, say, the 1960s and 70s. And you read, the fairness doctrine is well publicized, but you read communication scholars at the time talking about a day in the life of the FCC. And I saw one estimate, 2/3 of FCC time was spent doing broadcast issues, that is media issues. And I worry we're headed that way with Section 230 because it is a media issue. It is a lawmaker access to constituents issue. And that's why it's become so all-consuming. But we have our political class and the leaders at our tech companies just consumed by it when they can do so much better things. And two pet issues of mine when it comes to media policy that I think are much more fruitful areas for lawmakers and others working in the space is one is a public forum doctrine online. Whether we like it or not, courts are holding in case after case that lawmakers' social media accounts are public forums. The question becomes what restrictions, if any, are there on private companies to unilaterally remove public forums from the internet? I'll point to one case in Vancouver, Washington State last year. YouTube removed a public hearing where some people were discussing, I think COVID was part of the controversy. We don't know because YouTube pulled the video from this public hearing from this public school district because it violated their medical misinformation content. What are free speech and First Amendment issues of private actors moving public forums unilaterally online? I'm not sure, but I think that's a much more fruitful avenue for free speech advocates, and obviously ties into conservative advocacy. And actually, this was an element. Twitter has Donald Trump has a lawsuit against Twitter, and there's a brief argument about this. I'll be interested to see how the court in California approaches it because this is a live issue. The other is state action online. Again, there's some relevant litigation here. Alex Berenson he's a former New York Times journalist, and he has litigation against Twitter. Much of the lawsuit, I don't think comes to much, but there is this argument about state action and the fact that the Biden administration last summer said they were working with tech companies, their staff was working with tech companies to remove medical misinformation. Alex Berenson believes he was part of that purge of social media accounts, and there could be a state action claim. But it's not just his. There were reports in Politico that protests, anti-vaccine protests were shut down at the request of state officials, and there are others like this. And this is state action arguments, and I think a much more fruitful area that is not Section 230 related. Which again, as someone who is in right of center circles, I find it really confounding that conservative advocates and libertarians are wrapped around the axle on this Section 230 issue when there are speech harms online. Anyways, Adam, back to you.
Yeah, Kristian, I'll welcome some follow-up comments on that, but let me just say to our audience that's listening, feel free to pose any questions you might have for Kristian or Brent in the chat box, and I'll do my best to try to get to them. We've got a little bit more time here. But Kristian, I'll invite you to say anything and comment to what Brent had to say, but I will say one thing in turning it back to you for some more comments, which is, it seems to me like Brent has teed up just a couple more issues here to add on to the ones that you've already raised and that many, many other people have raised in terms of reasons to reform 230. This gets to what some scholars are referring to as a sort of the Swiss cheese problem of sort of 230 reform. It seems like at some point, if everybody got their way, then this law would become essentially meaningless.
Right.
And so I guess one skeptical question back to you is, like, if we open this thing up at all to do anything, it seems like once the floodgates are open, a lot of stuff gets on. And maybe this is just a practical political question. You're talking about what I would regard as more like a surgical strike approach to dealing with the most heinous crimes or harms of a non-speech, non-communication related variety, correct? And that would be your preferred approach.
Right.
Is that doable?
Well, okay, lots of material from both of you. I'll try to tie it all together in a big bow. Generally, I agree with a lot of what you're saying, but I'll distinguish some of how I'm thinking about it, and I think how my co-authors think about these problems. I do think that I agree it's difficult to do an economic analysis when you have speech issues involved, but that's not to say that it's impossible. So even you mentioned the fairness doctrine, the Supreme Court essentially rooted its view of the fairness doctrine in a cost-benefit analysis about administration of scarce spectrum. So that's kind of in the background in a lot of the communications policy. It could become overwhelming, and that's exactly why I think that what the lawmakers need to avoid is creating something, even if we can assume that it would pass First Amendment rigor, creating some sort of like speech agency that's responsible for administering these speech codes. I just don't know that it's possible. And then to Adam's point on the Swiss cheese issue, whether our surgical strike is too surgical or not broad enough, maybe that needs to change. One of the other things that motivates the way we're looking at Section 230 reform is that taking a issue by issue approach. We had FOSTA SESTA, and now everybody keeps looking for other ways that they can do these carve outs in Section 230. I think ultimately that doesn't do what everybody wants it to do. I think that it creates far too narrow exceptions in some ways, but then it creates sort of like a broad hammer in other situations. I think that what you need is to have publicly agreed upon standards that everybody is aware is working out there, and that these companies are binding themselves to these court proceedings, and that allow the courts in adjudication procedures to figure out where this line needs to sit, given the unique features of how the internet works relative to these other media. So I think Brent's right that what the common law would have arrived at is something like conduit liability. I think that there's probably more to it than that, though, because the internet is different than a broadcast network, and it is different than traditional publishers. Social norms are weaker online. Anonymity or pseudonymity is sort of how everything runs on the internet. That makes self-help much more difficult. The scale of platforms makes the ability to amplify harmful content much greater. So I think courts would take these factors into consideration. Now, the cost benefit analysis they do in weighing, the value of speech versus the harms that it commit, I don't know that it's going to be something, again, that has mathematical precision, but it's going to be something that can be iterated over court decisions. So I am optimistic that you can still see a law and economics informed adjudication process that emerges there. To Brent's other point, I actually agree. I think the Section 230 conversation is useful in the same way that people talk about antitrust as a way to chase in big tech. I think a lot of the arguments that you see emerging from the populists that want to go after big tech using antitrust, they really make no sense based on the history of how competition law has worked, in the same way that trying to use the threat of reforming Section 230 to force conservative speech to stay online or to take down hate speech, I don't think that those things actually make sense in a First Amendment context. So a lot of the attention that's being spent in both of those areas is a lot of heat, a lot of fundraising, but they're not actually trying to do something that I think on net will yield better social benefits. Looking at where the state action doctrine starts to actually have teeth. So like, as Brent noted, all the cases on the state action issue, I think so far have basically not gone the way of saying that that there was the implication that there's been federal involvement to the extent that it becomes something that can be regulated. But there can be a line for sure where the government does start to involve itself with these companies in a way where it does look like there's some direction there, and you can see the state action. The same thing with the public forum issue. When you don't have local news the way you used to, when you don't have as much newspaper consumption, you have more people getting their news from Reddit or Twitter or YouTube, especially local news like those things. At what point does the public forum doctrine start to say that you can't actually just take these down because of your particular preferred policies on a particular content area? I think those are real. That is where a lot of this action is. Unfortunately, it's harder to message politically around those things.
We've got a number of questions coming in. I'm doing my best to sort through them. Let me try to combine a few of them for both of you. One comes from my old friend, Solveig Singleton, and she has a couple of questions, one of which is, How does this issue relate to ongoing disputes about copyright enforcement? And just to build on her question, one could ask, are we moving towards something more akin to a traditional notice and takedown regime like we've had since copyright was originally carved out from 230? And then another question here is from Larry Joseph. He says Section 230C 2A covers material that the provider considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. It is primarily the last one, otherwise objectionable, that tends to get applied selectively on political grounds. What's the justification for the vague, otherwise objectionable criterion? So two different questions there. I'll let you guys decide if you want to say anything on either of those questions from our audience.
You want to go first, Brent?
Yeah. I mean, on the copyright, so copyright is an exception to Section 230, right? I mean, this has been carved out by Congress. So there can be liability for copyrights. Although it's not really a due care standard, it's a notice and takedown. You've got to be, if you're an internet intermediary of some kind, once you've received notice of a copyright violation, there's a duty to remove it. And by the way, I don't think I mentioned, but when I was talking about mine and Jennifer's proposal for how you could modify Section 230 slightly in the future, it would be a notice and takedown standard, not a liability or a due standard or due care standard. So copyright is not part of Section 230 really. And I think if there are any conservatives who believe removing Section 230 to be some boon to conservative speech online, I'll point you to one example of why that might not be the case. Again, we have this natural experiment of no Section 230 protection for copyright issues. And in 2020, in the run up to the election, there was a Twitter user, Carpe Donctum, who created a satirical video of CNN. It's all been removed by now. You might be able to find it, but it was a satirical video of CNN. It got retweeted by President Trump. Carpe Donctum calls himself, I think, a pro-Trump meme smith. He was very active in conservative politics. Twitter kicked him off in part because of this alleged copyright violation for repurposing the CNN clip. And this was bogus to anyone who saw it at the time, and we know it was bogus because there was later litigation in New York State Court. The owners of the copyright of the video sued Carpe Donctum in state court, and the judge threw it out on anti-SLAPP grounds. Said this is clearly a satire. So this idea, I think some conservatives hold, that without Section 230, you would see all this conservative, all this dissonant speech. It's just not the case. I think Carpe Donctum is a great example of where you have an area of law exempt from Section 230, copyright, that's being abused by political actors and is getting people removed from social media. So now, I mean, I hope if nothing else, people come away with that. I mean, this idea that removing Section 230 would be a boon to conservative speech. Look at Europe; they don't have Section 230. Is conservative speech in a better or worse position there? Look at copyright and the abuse of copyright for political purposes. I'll leave it at that.
Well, it's a good point, and I mean, one thing we need to differentiate is that there's Section 230, and then there's the First Amendment too, right? I mean, right. So there's a lot of other factors that are in play here. But anyway, Kristian, a quick comment from you, and then I have a couple more questions
quickly
from the audience.
Sure. On the notice and takedown point, I think Section 512, which is the copyright law that's relevant on that question, certainly needs some help. There's been ways that it has not worked as expected, I think, over the last 20 years. I would not immediately replicate a notice and takedown system for Section 230. I just don't know that is the right way to go about that. Maybe for something like what I mentioned earlier, where you have a no-fault injunction that declares that certain content is defamatory or otherwise tortious. maybe there's an obligation to take down on notice for that. On the conservative speech point, to what Brent's saying and to what Brent's earlier comments on the state action and the public forum issues, I think that's 100% correct, that if you repeal Section 230, you would see less conservative speech online. I think that it's not an unexpected occurrence that the major media institutions were all of a sort of center left or left wing bent before you had the internet explode. Fox News came out in the 90s. Sure, that's a counterpoint, but overwhelmingly the consensus in newspapers and traditional media tended to have a liberal bent. The way the internet has run has given room for people who do not subscribe to a liberal orthodoxy to actually collect and discuss things. Now, there's times when I'm sympathetic, where there's some people who get taken down where you're like, clearly that person was not someone you want to take down. But you need to be able to step back and look at what the costs and benefits are of removing the law that makes it possible for companies to not have automatic liability whenever someone says something mildly offensive. And like it or not, there are plenty of people on the right who say things that are mildly or worse, and people would be happy to sue platforms to get them to take that speech down, absent Section 230.
I got a couple more questions here. Brent, go ahead quickly.
Just quickly on Section 512. I've posed this question before. There is an interesting provision in Section 512, and I'm not a copyright lawyer, but I think it would be fruitful for copyright lawyers to look into. There's a safe harbor for copyright infringement, but only if for internet infrastructure companies, and I'm not talking social media companies, internet infrastructure companies, if, quote, transmission and storage is carried out through an automatic technical process without selection of the material, end quote. It seems like some companies are moving away from that automatic process. There's no litigation that I know of, but it's an interesting provision of law that I think will probably have some relevance in the near.
Let me try to throw out just a couple more questions. Trudy has an interesting question here. It sounds like something you might see in a law school exam. Is there currently liability for publisher distribution of an outdated negative article using search engine optimization methods of an individual private citizen's name for the sole purpose of ranking higher on Google search results?
That does sound like a law school exam.
Yeah, there's a lot tied up into that one. I think the answer is no. I would special liability there.
Yeah, squinting at it, I would guess that was a no on that.
Yeah, right. Thank you for that question, though, Trudy. That was a fun one. There's an anonymous question here you guys may have seen here regarding the question of state actors. How would you distinguish from the standard political working the refs that regularly occurs in many industries from across the line to a state actor? What consequences would restrictions applied to online actors have for the real world and its private actors that may not want to host a political figures event in their hotel ballroom, for example? Brent, you want to go first on that? Any thoughts?
Yeah, I've given a little bit of thought to this. The Supreme Court standard is if there's a sufficiently close nexus of a state actor and the private action. That's obviously pretty vague. Some thoughts. I don't think the kind of routine bullying of companies that you see in like hearings, or even say from the White House would qualify. What I mentioned earlier was a little different. This was a White House spokeswoman saying our staff is working with tech companies to remove anti-vaccine material. And they also identified 12 individuals. That seems like state action. I mean, that seems clearly. And there's another example. Last fall, 14 state attorneys general had questions for Facebook, and amongst their questions was, let me see if I can get the line. YouTube recently committed to banning several anti-vaccine activists, including some names. Will Facebook make a similar commitment? That's state action. I mean, you have 14 state attorneys general naming people and viewpoints and saying, will you commit to removing this? We don't always, we know it when we see it. It's not the routine bullying and things we see in hearings or even from. It's not even just mere questions, but I think particularly when you have law enforcement agencies like the executive branch or attorneys general doing it, it's something different than jawboning from Congress.
Yeah, I think that's a fair point. Guys, we've only got a couple of minutes left here. I want to ask you just a final closing thought question, which is, I think a lot of our listeners would be interested in knowing what you guys think is going to happen this year, and maybe just sort of gaze into that crystal ball just a little bit. State versus federal level, we've seen at least two states enjoying Texas and Florida, right? Their efforts have been enjoying a lot more percolating out there. Are we going to see anything stick in Congress or anything that is going through at the state level pass muster in the courts in the next 2 to 3 years? Brent, why don't we start with you and then we'll give Kristian the final word.
I don't think so. And this gets back to it can be done, but it's hard to improve on kind of the default rules by Section 230, and courts are just they just have a very high standard when it comes to speech for any political or state laws that touch on that. And I mean, the laws I've seen are pretty hastily drafted. I mean, they're political documents, and I mean, it just it's not very promising. But I imagine there'll be action. I mean, this is what I'm worried about. We had in the past when the FCC was very involved in broadcast media and regulated broadcast media pretty heavily, and this dominated regulators and lawmakers' time to an extent that it's really hard to understand today. But we're seeing some of that. And I think it's a shame. I think there are more fruitful avenues if you care about free speech and dissident speech of right or left. But I haven't seen much progress to date.
Kristian, final word to you.
Sure. I generally agree with a lot of what Brent just said. I think that there is more of a risk, however, insofar as we are increasingly in a populist moment, and I don't think it takes much for people who are of a left-wing populist sentiment and populist sentiment to figure out a sort of Venn diagram of what they think they can get to go after big tech. The problem is with a lot of the bills that I see and the efforts that are being pushed is that I do think that largely they are mostly political documents. They are meant for fundraising purposes and for signaling to your base. So to the extent that they do those sorts of things, I don't think that you're going to see those move. But where they can find bad ideas to agree on together, I wouldn't foreclose the idea that they could pass a law, which is why I think it's important to, if you really are interested in figuring out how to make things move forward, you do need to, I think, look at how to fix the actual quantifiable harms in the current regime, look at things like Brent's talking about with the state action issues and the public forum issues, and really look at like what demonstrably you can do that isn't solely for the purposes of fundraising. So
makes sense. Well, that's it for our discussion. I'm going to kick it back to Jack. I'll just say that you can find Kristian's new study at laweconcenter.org. And you can find Brent's work and my work on these issues at Mercatus.org. And you can find all of us on Twitter under our own names there. You can search for us for as long as we're there and not deplatformed. So we're there for a bit longer. So Jack, back to you, and thanks for hosting us.
Thank you, Adam. Thanks for moderating today. And a big thank you to Brent and Kristian for joining us as well. And thank you to our audience for tuning into today's virtual event. You can check out our website at regproject.org or throw us a follow on any of the major social media platforms at FedSoc RTP to stay up to date. And with that, we are adjourned.